For some of you, we haven't seen you in some time. Others, we've just seen you recently, but to all of you, welcome back. We're very grateful that you are here so we can get underway. We're now in a position to begin the evidence phase of this trial that we discussed with each of you during the jury selection process. We're going to begin with the administration of an oath to each of you by the jury clerk. Then you'll be impaneled, which is a brief formality, and then I'll give you a brief orientation as to how this matter will proceed from this point forward. So, Madam Clerk, would you please administer an oath to the jurors?
Jurors, would you please stand? You just want to place your left hand on the Bible, raise your right.
I think there should be enough Bibles for everyone to share.
I will say the oath, and you will say, yes, I will, I do. Please say your name aloud. Do solemnly swear that I will support and maintain the Constitution and laws of the United States and the Constitution and laws of North Carolina, not inconsistent therewith, that I will faithfully discharge the duties of my office as a juror, so help me God. The second oath, I will say the same. You will say, yes, I do, I will. I do solemnly swear that I will truthfully, without prejudice or partiality, try the issues in civil or criminal actions that come before you and give true verdicts. And this be your solemn affirmation. Thank you.
Thank you, ma'am.
If you'll just pass those Bibles down to the bailiff, pass them to your left, please, or right. All right, Madam Clerk, would you impanel the jurors, please?
Ladies and gentlemen of the jury, you have all been duly sworn and are now impaneled to hear the evidence wherein the state of North Carolina versus Nathan Lorenzo Holden. Sit together, hear the evidence, and render your verdict accordingly.
All right, ladies and gentlemen, you've now been selected, sworn, and impaneled to serve as jurors in the case of the state of North Carolina versus Nathan Holden. At this time, I want to explain to you a little bit more about the manner in which we will proceed as we attempt together to find the truth in this case. First of all, the attorneys will have an opportunity to make opening statement. The purpose of an opening statement is narrow and limited. It's an outline of what the attorney believes the competent and admissible evidence in this case will be. An opening statement is not evidence and must not be considered by you as evidence. Following the opening statement, evidence will be offered. Witnesses will be placed under oath and will be questioned by the attorneys. It may be that documents and other tangible exhibits are offered and received into evidence, and it may be that those documents are given to you to examine. If you're given a document to examine, you should do so carefully, individually, and without comment. It is the right of an attorney to object when testimony or other evidence is offered that the attorney believes is not admissible. When the court sustains an objection to a question, the jurors must disregard the question and any answer if one has been given, and you should not speculate or guess as to what the witness might have said had the witness been allowed to answer. When a court overrules an objection to any evidence, you must not give that evidence any greater weight than as if the objection had not been made. If the court grants a motion to strike all or some of the answer of a witness to a question, you must disregard and not consider that portion of the evidence that I have ordered to be stricken. Now, during the course of this trial, there may be questions of law that will arise that require our consideration outside of the courtroom. And when that occurs, I'll ask you to leave the courtroom. Either I'll send you back into the deliberation room, or if it's going to take us a bit longer, I may call a recess for your benefit while we continue to work. But in any event, you should not concern yourself or speculate as to what's occurring in the courtroom during your absence. Again, these are issues that the law requires us to consider outside of the presence of the jury, and you should rest assured that all of the competent and admissible evidence in this case will be presented while you're in the courtroom. Once the evidence is completed, the attorneys will have an opportunity to make final statements or closing arguments. The final arguments of the attorneys are not evidence, but are given to assist you in your evaluation of the evidence. And then finally, just before you retire to consider your verdict in this case, I will instruct you on the law. I will declare the law that arises from the evidence. I will explain that law to you, and you'll then be taken to the jury room to begin your deliberations. I do want to remind you of a few preliminary things about the law as it applies to all criminal cases. As you know, as I've told you previously, that the defendant in this case has entered pleas of not guilty. Under our system of justice, a defendant who pleads not guilty is not required to prove his innocence, but is presumed to be innocent. And this presumption remains with the defendant throughout the trial until the jury selected to hear the case is convinced from the facts and the law beyond a reasonable doubt of the guilt of the defendant. The burden of proof is on the state to prove to you the defendant is guilty beyond a reasonable doubt. There is no burden or duty of any kind on the defendant. The mere fact that the defendant has been charged with a crime is not evidence of guilt. A charge is merely the mechanical or administrative way by which a person is brought to trial. If the state proves guilt beyond a reasonable doubt, then it will be the function and duty of this jury through its verdict to say guilty. If the state fails to prove guilt, or if you have a reasonable doubt, then of course it would be the function and duty of this jury through its verdict to say not guilty. I also wish to remind you of an instruction that I gave you previously. The fact that the defendant was restrained at one point during these proceedings, or the fact that he is elected to wear certain clothing in these proceedings, is to have no bearing on your consideration or weighing of the evidence or determination of your verdict in this case.
Your Honor, I believe that the jury needs to be instructed on truth and the Constitution and not a white man's interpretation of law. And as a free Negro, I believe that the jury needs to be instructed to the Constitution, not your interpretation.
I also want to mention the fact of possible news media coverage during this trial. During the course of the trial, you may notice TV cameras or camera equipment in the courtroom or in the courthouse. Media coverage of jurors is expressly prohibited at any portion of these proceedings, including the portion in which the jury was selected. The camera persons and the photographers are not permitted to take pictures of you. Therefore, you should not even consider whether this trial or any portion of it will be covered by the media by any of the means that I've mentioned. It will not affect you personally or this trial, and I urge you to put this matter out of your mind. I also want to go over the rules that I know you've been instructed on previously. You each have a sheet that explains these rules in detail. It is critical that you follow these rules until you are excused from this trial at the end of the proceedings. Again, the rules in a shortened form are: you must not talk about this case among yourselves. The only place jurors can talk about a case among themselves will be in the jury room, and then only after I've instructed you to begin your deliberations. And I do want to caution you, please follow this rule to the letter. There's a great temptation to talk about the case among yourselves. Many of you have never served on jury service before, so all of this will be new to you. I expect that you'll find portions of it interesting. You will want to talk about it with those of you who are sharing this experience, but I caution you that it is very important that you not do that, that you form the opinions that you make about this case by yourself, using your own common sense and reason. Once you reach your deliberation, you'll share those opinions with your fellow jurors. And so it's very important that you not discuss your thoughts or impressions or observations about this case until you reach that point of deliberations. Secondly, don't talk about this case with anyone else, including your family members or friends, and don't allow anyone to talk about it in your presence. If anyone were to communicate with you about this case, you should bring that to my attention immediately. I would emphasize that in this age of electronic communication, this rule would prohibit you from posting your status or making any comments about this case on any social media, such as Twitter or Facebook or anything of that sort. So please don't do that. Simply wait until the end of this proceeding when you're excused. Then you can talk about this case as much as you choose. But as you serve as a juror, we ask that you not make any comments about this case whatsoever. Third, as you sit as a juror, please don't form or express any opinions about the outcome of this case until I ask you to begin your deliberations. Again, this rule simply asks you to keep an open mind during these proceedings. Fourth, please don't talk or communicate in any way with any parties, witnesses, or lawyers involved in this case. And this rule applies both inside and outside this courtroom, and it applies even to the most casual of conversations, such as asking the time of day or the weather or anything else. You all have red badges. I ask you to wear them at all times that you're around the courthouse. You'll take them home with you at night, take them off when you get in your car, put them back on when you're leaving your car in the mornings. That way, everyone involved in this case will be able to note that you're a juror and will give you plenty of space so that there is no possibility of communication. So I would just ask you to follow this rule scrupulously as well. Next, please don't read, view, or listen to any media coverage of this matter. And again, you're advised that there is likely to be coverage of this case, and you're instructed not to read, view, or listen to that coverage. And finally, please don't conduct any independent investigation, either by looking up anything related to this case, the law, the people, facts, things, or anything else, visiting the scene of the alleged incidents, or anything else that would constitute your own investigation. All the information you need to decide this case will be provided to you in this courtroom, to which you'll apply your reason and common sense. Now, each of you must obey these rules to the letter. Unless you do so, there is no way the parties can be assured of the fairness and impartiality of this jury. It is your duty, while this trial is in progress, or while it's in recess, or while you're in the jury room, to see to it that you remain true and impartial triers of fact. If you violate these rules, you're violating an order of this court, and you could be subjected to or subject to contempt of court. But more importantly, as you can see, these rules are designed to ensure the fairness of these proceedings for all involved. A couple housekeeping matters before we move on to the opening statements. First of all, in my discretion, you will be permitted to take notes during this trial. You are provided with notepads that the bailiffs have provided to you and pens. If you do choose to take notes, I ask that you do so in the notepads that you've been provided. These notepads are to remain in the courtroom throughout the trial until you begin your deliberations, at which time you'll be permitted to take your notepads with you into the deliberation room. When you begin your deliberations, you can use your notes to help refresh your memory as to what was said in court. I caution you, however, don't give your notes or the notes of any other jurors undue significance. While taking notes, a juror may fail to hear important portions of testimony. Any notes taken by you are not considered evidence in this case. Your notes are not the official transcript of this trial, and for that reason, you must remember in your jury deliberations that notes are not entitled to any greater weight than the individual recollection of other jurors. If you do take notes, don't disclose them to anyone except your fellow jurors during your deliberations. Don't let your note-taking distract you. Listen intently at all times to the testimony. Briefly about the schedule that we follow, I think we may have mentioned that to you previously during jury selection, but generally we start court at 9:30 in the morning and we recess at 5 o'clock in the afternoon. We generally take a lunch recess around 1 o'clock for an hour and a half. We take a mid-morning recess and a mid-afternoon recess of about 15 minutes each. If at any time during these proceedings you need a break for any reason whatsoever, simply raise your hand, catch my attention or a bailiff's attention. We'll do everything we can to accommodate you and make sure that you are comfortable. The jury room in the back that I believe you've already seen is there for your use and your use alone during this trial. You can leave snacks or reading materials or sweaters or your lunch, whatever you care to leave back there. That's a secure hallway back there. And so feel free to do that. While we're in session, you should feel free to bring beverage, coffee or water with you into the courtroom. I would ask that you use a closed container of some sort that we don't spill it on our nice new courthouse facilities here. It's very important that you be able to see and hear everything that's going on in these proceedings. If there comes a time that you can't see or hear a witness or see an exhibit, let us know, raise your hand, catch my attention so that we can take steps to make sure that you can see and hear everything that's going on. You will note from time to time, you'll see me working on a computer at the bench or referencing legal materials that are available for my use during this trial. I'm generally working on matters relating to this case, but I am listening to every word that's being said in this courtroom, but I bring this to your attention because I don't want you to be distracted by anything that I am doing at the bench. Your job is to listen carefully to the evidence in this case, and you should not draw any inference from anything that I am doing that any evidence is any more important or any less important. All of the evidence in this case is important, and you should listen carefully to all of the evidence as it's presented. So at this time, ladies and gentlemen, it's time for the opening statements. We'll hear the first opening statement from the state, and then we'll hear the next opening statement from the defense if the defense wishes to make an opening statement at this time. Mr. Waller, Mr. Lively.
Thank you, Your Honor. May it please the court. Through the eyes of the children. Amber and Nautica were 8 years old back on April 9th of 2014. They'd had a good day. They went to school, they came home, and then they went to church with their grandmother, Anglia Taylor. It was a good day. They came home after church, and Nautica went and stayed with her mother in the back bedroom. Her mom hadn't gone to church that night. She wasn't feeling well. And Amber stayed up in the front of the house with her grandma. It was a good day for them. They were having a fun day. The last several months hadn't been all that fun for them. Their parents had decided to split up in December of 2013. There were some custody issues back and forth, and the girls had stayed with their mom some, they'd stayed with their dad some. But for the last several months, they've been spending the weeks with their their mom, and the weekends with their dad and their older brother, JT. April 9th of 2014 was a pretty good day for JT as well. Jerry, 14-year-old young man, back on April 9th of 2014. He had a good day. He went to school. His father picked him up, took him by the house where he was staying with his father, and they left. They left the house there, and something that really didn't mean a whole lot to JT at the time happened when they left the house. They stopped on the side of the road right there outside of Holden Acres. And JT saw his dad pick up a bag. The bag between. And at that point, the defendant asked JT whether or not he wanted to go see his mom. And JT really didn't think a whole lot of that. You see, he was staying with his dad at that time and was visiting his mom on a regular basis, so he almost just didn't respond. They went by the church, Zion Hill Holiness Church, to look for his mom that night. She wasn't there, so they went on to Sonic. Had a nice little dinner there. JT was a little surprised by that. It seemed a little unusual because his dad normally didn't take him out to eat. But while they were there, his dad again asked him, "Do you want to go see your mom?" And again, he really didn't respond, didn't think much of it. And at that point, they left Sonic and they went to where LaTanya and her family were staying. JT got out of the truck, went inside the house, and he passed by his grandfather, Sylvester Taylor. You'll hear more about Sylvester Taylor during the course of this trial, but he's a military man. Sylvester said, "Hey boy, pull your pants up, they're sagging." JT kind of laughed him off and went back, and he also hung out with his mom in the back bedroom there for a few months. You see, April 9th was a good day for him as well, and it had been rough on JT the last several months. He had been through a lot. When his parents separated back in December, one of the reasons why his mom decided to leave is because his dad had beat him with a broom. And LaTanya said, "Hey, that's enough. It's time to go." And so JT had to endure the custody issues as well. And he's a young man. He's 14 years old. He's torn with staying with the mother that he loves and staying with his dad, trying to decide how best he can help the situation, how best to help keep the peace. You see that his dad had been acting different towards him since the separation. His dad was trying to be his buddy now, trying to be his friend. That was different for JT. So on April 9th of 2014, when he went and got in his mom's bed there at Lake Glad Road outside of Wendell, JT had no idea how his life was about to change forever. LaTanya. She was LaTanya Holden back in April 9th of 2014. She now goes by LaTanya Allen. April 9th of 2014 was not a good day for her. She had certainly been through a lot the last few months with the custody issues with her now ex-husband, the defendant. She will tell you how when she decided to leave in December of 2013, it was after years of the marriage just not being what it should be. And she'll tell you that breaking point was when the defendant beat his son with a broom. She'll tell you that when she went to the courthouse on January 2nd of 2014, that was the most scared she'd ever been in her life. Why was that? Because on January 2nd of 2014, the defendant also came down here to the courthouse. You'll hear from her how he followed her around, how he harassed her, how he threatened to physically harm her right out in front of this very courthouse. How she was finally able to lose him in a traffic chase almost, and go back to the courthouse where she was able to go in with being escorted by Wake County Sheriff's officers and get a restraining order against the defendant and file for custody of the children. And she got custody of the children at that point. But then you'll hear that in late January of 2014, January 26th of 2014, there was an incident between her father, Sylvester Taylor, and her son, JT, Jeremy. Jeremy was upset about Sylvester taking his phone from him, said Sylvester slapped him, took his phone from him, and on January 27th, he told his father and some school resource officers or some school guidance counselors that a gun had been pulled on him. You will hear from JT that that's not what happened, that there was no gun involved. But that shook things up. And that's the point in which JT started staying with his father during the week and the girls started staying with the mother. So they'd all been through a lot. April 9th of 2014, in a moment, changed from a good day for JT and Nautica and Amber, and a bad day got worse for LaTanya. When JT went into the back bedroom with his mom, Nautica was back there. She was surprised to see him, wasn't expecting him to be there. The next thing she hears, LaTanya hears, and JT hears, is the defendant, Nathan Holden, coming into that house saying, "Somebody's going to talk to me now." And the next thing she hears, and he hears, is a gunshot. They then hear Sylvester Taylor running through that house. And then they hear Anglia Taylor shout for Sylvester, and then another gunshot. At that point, Amber runs into the bedroom where her mother is. And at that point, LaTanya did what any mother would do. She took her attention and she focused it on her kids and did everything she could to keep them safe. She put them in a closet, told them that she loved them. told them that she loved them because she didn't know if she was ever going to see him again. She picked up the phone and called 911, and you'll hear that 911 tape here in this courtroom. And you will hear her say that my ex-husband is here, and he's shooting. And then the phone goes dead. Because after LaTanya gets the kids in the closet, she hears some more gunshots, and the next thing she knows is this defendant, Nathan Holden, is standing at her bedroom door holding a gun. And at that point, he turns his attention to her. And he begins to beat her with that gun in the face. And then he shoots her in the face. And you will hear Dr. O'Neill from Wake Med say that that bullet just happened to glance off of her tooth. One fraction of a hair, one way, the other way, and that bullet goes through her nose and through her brain. But that's not enough. At that point, she literally gets down on her knees and begs for her life. And at that point, the defendant makes the choice to shoot her in the chest. And you will hear Dr. Bolton from Wake Med tell you that he has no idea how the path of that bullet did not kill her. That it strikes a ventricle, goes through her body, striking other organs. That's not enough. You will hear that there is a third bullet there at the scene that for some reason jammed. At that point, LaTanya will tell you that she doesn't remember anything else. After being on her knees and saying Jesus and seeing the defendant pull the trigger and shoot her in the chest. At that point, the defendant, after he has committed these acts, goes to the closet where the kids are, gets them out, tells them he loves them, and hands them a phone. And then he flees the scene. He goes back to his house, and he's later arrested in the woods behind his house, still in possession of the same firearm that killed Anglia Taylor, killed Sylvester Taylor, and seriously injured and almost killed LaTanya Allen. That's from the children's perspective and from LaTanya's perspective. You'll hear that the follow-up investigation by the Wake County Sheriff's Office and the City County Bureau of Identification and the SBI confirm or corroborate this account. You'll hear about the different shell casings in the house, all matching to that gun. How there are 2 shell casings in the very front of the house, a shell casing in Anglia's room, shell casings in LaTanya's room, and shell casings outside where Sylvester was found. You'll hear about how SBI tested the gun and the defendant's clothing, and how you'll hear that the bullets, one, match, but also that there was DNA evidence of LaTanya on the muzzle of that gun. And her blood was on his clothes. Ladies and gentlemen, that's an overview of what I believe you will hear the next couple weeks. It's not everything. At the end of the case, Mr. Lively is going to come back to you and talk to you about what you hear from that witness stand, how it goes along or meshes with the theories of first-degree murder that I believe you will hear about. What I would ask you to do up until that point is to listen very carefully. And listen to what the defendant did, not just that night, but starting in January. Listen to what you hear about what he was doing, what he was thinking, what he was intending. Think about his path that night of April 9th, how he took Jeremy on that ride, and the end result. Think about what he was doing. Ladies and gentlemen, We thank you for the time that you have already spent with us, and we thank you for doing your civic duty.
Thank you, Mr. Waller. Ms. Hamburger and Mr. Brown, opening statement for the defense.
Good morning, ladies and gentlemen. It's nice to see y'all again. This case is about a family. Nate Holden is charged with hurting some of the people closest to him, with killing his in-laws, assaulting his wife. Our hearts go out to the Taylor family. Everyone in this room can agree that what happened was a tragedy. It's heartbreaking that Mr. and Mrs. Taylor are dead, that LaTanya was injured, and that their children had to witness this horror. But this case is not a whodunit. This is not about what happened. Nate Holden is the one who is responsible for the deaths of Mr. and Mrs. Taylor. He did shoot his wife. What we want you to understand is how things got to this point within this particular family. This case is about why this happened, and it is about Nate Holden's state of mind at the time it happened. When you hear all of the circumstances, you will learn that he is not guilty of first-degree murder. Nate grew up here in eastern Wake County. He and LaTanya Taylor met in middle school when they were teenagers. They began dating. LaTanya got pregnant and gave birth to their first child, Jeremy, when Nate was only 15 years old. They got married a few years later, had 2 more children together, Nautica and Amber. And Nate took his role as husband and father very seriously. Nate had had a rough childhood, and he vowed that he was going to do different, that he was going to do better than his own family had. He vowed that he was never going to put his hands on a woman, that he was going to have all of his children with the same woman, that he was going to be there for his children, that he was going to keep his family together at all costs. He was an involved father. He planned meals. He cooked for his kids. He took care of them while his wife was working. He considered himself their teacher, their guide. He did his very best to make sure that his family was provided for. Like many marriages, this one was not perfect. They had gotten together very young, as teenagers. They had their problems. One problem in the marriage was that LaTanya's father, Sylvester, had never really cared for Nate. The 2 of them did not get along. Another problem in the marriage, very common, was money, or not enough of it. But this is not a case about chronic domestic violence. Nate was not a batterer. In fact, the violence that happened in this case was the first act of violence between Nate and LaTanya during the course of their relationship. So after 10 years of marriage, LaTanya decided she wanted a divorce, and she wanted custody of the children. She moved in with her parents. But Nate, he didn't want the marriage to end. He thought they could work it out. They had worked out their problems in the past. He wanted to stay together. He had been married to LaTanya, or with her, for nearly half of his life. Remember, he got together with her when he was 14, 15 years old. At age 30, he was experiencing his first serious breakup, the loss of his first serious love relationship. And this wasn't just the breakdown of his marriage, but the breakdown of his dreams, of his life. He said some angry things when LaTanya said she wanted to leave and that she wanted the children. And LaTanya took out a restraining order against him. Nate and LaTanya both loved their children very, very, very much, and they both wanted to be with them. The court ordered that the kids go back and forth between the 2 parents, And as you can imagine, emotions ran particularly high at the time of the custody exchanges, when the children would move from one household to the other. The custody exchanges usually took place at the Wendell McDonald's. And about a month into the separation, there was a particularly difficult one. Nate and his father and his brother met his father-in-law, Sylvester, at the McDonald's to exchange the kids. This is because the kids had spent the weekend with Nate and they were going back to their mother and grandparents' house. Now, as I said, Nate and Sylvester had never gotten along. So this was a particularly tense situation when the two of them met, only a month into the separation. Sylvester even brought his gun with him, and he kept it visible on the front seat of his car, heightening the tension of the situation. There was a conversation, and it was a tense one, between Nate and Sylvester, and then the children left with Sylvester. And just a few minutes later, Nate got a call from Jeremy, his oldest child, and this is what Jeremy said. He said that when Sylvester and the kids got back to their house, Sylvester let the girls, the two young girls, he let them go into the house, but he kept Jeremy out in the car. He slapped him, he screamed at him, saying that Jeremy, who was just 14 years old at the time of this, that he had set him up by coming to the McDonald's, not just with his father, but with his grandfather and his uncle too. And while Sylvester was yelling at Jeremy, Sylvester still had the gun nearby, and Jeremy felt scared he might use it. This is what Jeremy said to his father on that night. Jeremy ran to a neighbor's, he called his father and told him this. Sylvester, meanwhile, called the police. And when a sheriff's deputy arrived, the deputy told Jeremy and Sylvester to stay away from each other. That's all he did. But Nate was frightened. He felt that Sylvester was dangerous. In fact, Sylvester had threatened to kill Nate on more than one occasion, even prior to the separation. Nate knew there were a lot of guns in the Taylor's home. He was scared of what might happen to his children if Sylvester lost his temper again. Nate's own difficult childhood also probably heightened his feelings of fear when he thought one of his own children was in danger. So he decided to seek full custody of the children. The situation escalated into a nasty custody dispute. It was complicated, but even still, Nate and LaTanya managed to co-parent. They communicated by text and phone about the children's needs. The children moved back and forth between the two homes and saw both of their parents during this time. But it was a custody dispute, and there were strong emotions on both sides, and people feeling strong emotions don't always act logically. On the evening of April 9th, 2014, Nate and Jeremy went together to the Taylor's home. Jeremy went inside first to say hello to his mothers and his mother, his sisters, and his grandparents. Nate stayed in the car. And you'll hear several accounts from this witness stand of what happened next. Shouting, chaos, shots fired. As jurors, your responsibility is to listen with an open mind to the testimony of the witnesses and to judge their credibility. And credibility here is more than whether people are lying or telling the truth. You will need to consider whether witnesses had the opportunity to observe what happened and to what extent their memories are accurate. None of the witnesses who will testify saw everything that happened that night. Also, you will be hearing evidence of the trauma that they went through, and you will have to consider whether trauma has affected their memory. When it was over, Nate had shot the Taylors and LaTanya. All Nate's anger and stress and fear and sadness about the divorce, about his children, it came pouring out. And he did something that was completely out of character for him. After, he called 911 himself. He hugged his children. He told them that he loved them. He called a couple of family members and asked them to take care of his kids. He had no plan for escape or what to do next, and he was arrested a few hours later near his home. We are not denying that Nate is the one who shot the Taylors and shot LaTanya. The pain this family has been through is truly heartbreaking, and we are not here to justify these acts. We couldn't if we tried. but we can say that what happened was completely out of character and done with no deliberation whatsoever. We ask you to keep an open mind as you listen to the evidence, and when all of the evidence is presented, we will be asking you to find Nate Holden not guilty of first-degree murder. Thank you.
Evidence for the state.